Thank you, Mr. Chairman. Members, my name is Ware Wendell. I'm the Deputy Director for the nonpartisan nonprofit group Texas Watch. We advocate on behalf of policyholders. Mr. Chairman, I know you've got a long day ahead of you, so I'm going to be to the point with my comments and focus on the substitute. First, I need to update some information that I gave y'all from the last hearing. I told you that in the last 4 quarters, homeowners carriers had pulled down a $1.47 billion underwriting profit. TDI has released updated figures. That number is now $1.56 billion. And auto insurers, private passenger auto insurers, I told you had pulled down $463 million in profits. That is now $667 million for the 4 quarters of 2014. So I wanted to be clear about that. We are opposed to Senate Bill 1628 because of its broad application. And I want to be very specific as I go through this. We've heard a lot of testimony about the hollowed out damages, how actual damages has been defined downward. And I would direct you to Section 2 of the substitute. Also in Section 10, for Chapter 542, dealing with prompt payment, it only talks about interest accruing on the unpaid portion of the claim. Here's the problem with that. If an insurance company comes to you and says, we'll pay you 75 cents on the dollar, you can't put on 75% of a roof. Either you have enough money to put on the roof or you don't. It's a binary decision, either or. And so what that does in effect is it incentivizes lowball settlements. And carriers can buy down their liability, but the policyholder is not benefited. 541, which as we've heard deals with deceptive practices, has very broad application. It involves all persons engaged in the business of insurance. That's as broad as it can be. So if we get in and start tinkering around with 541, we're touching every policyholder in the state. We're talking about billions of dollars at stake, millions of people. 541 and 542 focus on the conduct of the insurer. And we've heard talk about breach of contract. Who writes the contracts? The carriers do. That's the terrain that they want to fight on. They're going to win on exclusions, exceptions, etc. Policyholders need the protections and the additional damages that are possible under 541 to make it more likely that they get 100 cents on the dollar without having to walk across hot coals and take this all the way through court. In terms of expanded immunity, it does now broaden out the bill to agents potentially. And we've heard some talk about federal court. Mr. Chairman, there's a study from Syracuse that shows in the last 20 years, federal court cases now take 2/3 longer to resolve. The reason why is because of immigration cases clogging up the court, criminal cases. We're dealing with Mexican drug cartels in Texas. It's a delay tactic. That's the way that it will work in practice. It will hurt policyholders. There's a hard and short statute of limitations of 2 years that's unprecedented, that penalizes policyholders. And now insurers under this bill as written would have new defenses like a bona fide dispute. It's a trump card that they can play. We urge your opposition to the bill.
Thank you for being here. Members, any questions? If not, you're up.